So all this is going to be yours. Just don't mix it up because some of it has to go back to the court. So all this is yours. And they'll go over all that with you.
Are you looking at this?
Yeah.
Take it out.
Mhm.
All right, let me know if anyone cannot hear. We're on the record in cause number 241-1071-20, buying information charging the offense of burglary of habitation, state person designee, DES-NIQEV, Herndon, present before the court by Zoom, with his attorney, Mr. Rawlings, Mr. Anderson is present for the state, and also present is the court's probation officer, Marcella. You want to waive the reading presentation, but the information, all the other formalities is wrong.
We will, Judge.
All right, Mr. Herndon, raise your right hand and swear again. You solemnly swear the testimony you will give before the court today will be the truth, the whole truth, and nothing but the truth, and that all the documents which indicate you swore to the documents were signed and sworn to by you under oath with a full understanding of the meaning of the document.
Yes, sir.
All right, Mr. Herndon, first matter, do you understand the information in the case charges you with second-degree felony of burglary of a habitation? It's filed in by information. Do you understand that?
Yes, sir.
One of the documents is going to be a waiver of your right to have your case presented to a grand jury to determine whether or not a grand jury would indict you. Do you understand that?
Yes, sir.
You have a right to have your case presented to a Smith County grand jury, and the grand jury would determine whether or not there's sufficient evidence, probable cause to indict you. You are waiving by one of these forms having your case presented to a grand jury, agreeing to bypass the grand jury and appear before the court on information filed direct into court by Ms. Anderson, charging you with burglary of a habitation. Do you understand all that?
Yes, sir.
Do you understand all the allegations in the information which charge you with the offense of burglary of a habitation? Basically alleges on or about the 11th day of August 2019, before the filing of the information, in Smith County, the state of Texas, that you did then and there intentionally and knowingly enter a habitation without the effective consent of Caitlin Baker, the owner thereof, and attempted to commit or committed an assault against Caitlin Baker. Do you understand that that is the offense charged by the information?
Yes, sir.
You have an agreed punishment recommendation on all these plea documents. They're signed by Ms. Anderson, state's attorney. There's a signature, Dominic Herndon, not Desnick Herndon on there. They're all coming up on the screen like the first one. Is that your signature there, line above the line where it says defendant?
Yes, sir.
And then they're also signed by Mr. Rawlings, your attorney, and as I've said, by Ms. Anderson, state's attorney. If you enter a plea of guilty to that information, state's counsel, Ms. Anderson is going to recommend your sentence at 5 years deferred adjudicated probation. Is that your plea agreement?
Yes, sir.
Yes, sir, Judge.
Mr. Rawlings, all right, is that your recommendation, Ms. Anderson?
It is, Your Honor.
Is there any restitution due, Ms. Anderson, you know about?
No, Your Honor, there's no restitution in this case.
All right, state's recommendation being 5 years deferred adjudicated probation. The next document, Mr. Herndon, is an acknowledgement of admonishments. It's going up on the screen. Gives the full range of sentencing, not less than 2 to more than 20 years in TDC. Fine may be assessed of up to $10,000. You and your attorney have signed right below the 5th admonishment on the 2nd page. Do you understand all 5 admonishments?
Yes, sir.
Also, you signed a document waiving service of a copy of the information and waiving arraignment, also signed by your attorney. Do you understand that?
Yes, sir.
Also, you signed a waiver of trial by jury, and it says you understand you have a right to a jury trial whether you plead guilty or not guilty, but then it says that you, understanding your right to a jury trial, you knowingly, intentionally waive, meaning give up your right to a trial by jury, and just request the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes, sir.
Next document is a signed and sworn to waiver of confrontation. I'll fill in the sworn part after the plea. Do you understand the waiver of confrontation and agreement to stipulate testimony?
Yes, sir. Yes, sir.
The next document is the file marked information filed in by Ms. Anderson charging you with the offense. I've read from it to you. Do you understand the information, the charge against you?
Yes, sir.
And you understand that's a second-degree felony, carries a sentencing range of not less than 2 years, no more than 20 years in the Texas Department of Corrections Institutional Division. Do you understand that?
Yes, sir.
And you've filed a waiver of a felony plea. There is a waiver upon your felony plea of guilty to the information, waiver of 10 days to prepare for trial. Need to be sure you understand this, and Mr. Herndon, you signed and sworn to a stipulation of evidence, which is coming up on the screen. This is one of the documents I've signed and sworn you to. Do you understand that stipulation of evidence signed and sworn to by you? That is a written judicial confession under oath by you to the allegations and the charge in the information, burglary of habitation. Do you understand that?
Yes, sir.
Did you sign and swear to that stipulation of evidence, states to of your own free will, and sign it voluntarily?
Yes, sir.
All right, next document is an agreement to stipulate testimony. There's a form for a waiver of appeal, request to allow a waiver of the pre-sentence, which is approved, trial court certification of your rights to appeal. Document that you signed, your attorney have signed on the advice you've received from him on your rights to appeal. I've identified all the plea documents. Do you understand all the plea documents that you signed and sworn to?
Yes, sir.
Do you have any questions for the court about any of the plea documents that you signed?
No, sir.
All right, you understand if you do plead guilty to this information, the state's recommendation is going to be 5 years deferred adjudicated probation. Counsel, is there any restitution due?
No, sir, I don't think there's any restitution, Judge.
All right. We won't need a post sentence then. All right, Mr. Herndon, if you do not have any other questions for me, understanding the allegations and the charge and the information, the full range of sentencing in your plea agreement, what is your plea today to the information charging you with burglary of a habitation as alleged in the information? Like, what is your plea?
Oh, guilty.
Are you entering your plea of guilty because you are guilty and for no other reason?
Yes, sir.
I'm going to ask you some pretty simple questions just to follow up on that. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case and everything else you're doing in court today with your attorney?
Yes, sir.
Is he competent, Mr. Rollins?
Yes, sir, Judge.
Any evidence of incompetence?
He is competent.
Any evidence of incompetence?
No evidence of incompetence, Your Honor.
Court notes State's counsel signed her consent approves the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case and all the documents signed are signed and sworn to by the defendant. You have any questions for me about anything in the case here, Mr. Hearn?
No, sir.
All right, in cause number 241-1071-20, what is your plea today to the information in the case charging you with burglary of habitation, a second-degree felony as alleged in the information?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
You want threaten you anyway, promise you anything in court, you make you plead guilty?
No, sir.
Are you pleading guilty to the information today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the information?
Yes, sir.
Are you entering your plea of guilty to the information today because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
Yes, sir.
Let me slow down on that one. Listen real close. Are you entering your plea of guilty to the information today because you have any delusion in your mind or any type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Anderson?
Your Honor, we offer States 1, the plea packet with signed waivers and admonishments. States 2, the stipulation of evidence. And in this case, the defendant's pleading guilty to an information instead of an indictment, as well as States 3, the discovery compliance documents.
No objection, Judge.
No objection. The court admits into evidence States 1, all the plea documents. States 2, the signed sworn to stipulation of evidence, written judicial confession. States 3, discovery compliance. Court having admitted into evidence States Exhibits 1, 2, and 3. The court does find the defendant's waiver of his rights and execution of all these documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the information on file in this case was entered by the defendant to the information freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's plea of guilty to the information. However, the court does withhold the finding of guilt, and we will move to sentencing. Ms. Anderson.
Your Honor, we offer States 4, an electronic copy of the written discovery in this case, and I'll deliver that to the court office on the conclusion of this hearing.
No objection, Judge.
With no objection, States 4 submitted into evidence. The court in this case then, having received and accepted the defendant's plea of guilty to the offense alleged in the indictment, the court finding the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment, burglary of habitation. The court does withhold a finding of guilt as to the defendant follows the plea agreement, says that the sentence at 5 years, deferred adjudicated probation, no fine assessed, court costs are ordered paid, restitution is ordered, if due, to determine the amount by a post-sentence. Any legal reason to go formal sentencing, Mr. Rollins?
No, sir, Judge.
Monday now, the court does formally pronounce sentence. The court does find the evidence in the record fully sufficient to support the defendant's plea of guilty. The court receives and accepts the defendant's plea of guilty. Finding the evidence in the record fully sufficient to support the defendant's plea of guilty. However, the court does withhold the finding of guilt as to the defendant follows the plea agreement recommendation of the state. Says that the sentence in the case at 5 years, deferred adjudicated probation, no fines assessed, court costs are ordered paid. Restitution is ordered to be determined to finish due by a post-sentence. Sentence is formally pronounced. Mr. Herndon, one of the documents I have signed by you and your attorney is a waiver of your right to appeal. Are you presenting your waiver of appeal to the court today, understanding you are waiving giving up your right to appeal and waiving giving up your right to file a motion for new trial?
Yes, sir.
Court then does receive and accept the waiver of appeal and which also includes a waiver of right to file a motion for new trial or to file the papers of the cause. Under the judgment that will be signed this afternoon, Mr. Herndon, as of right now, you're on the court's deferred adjudicated probation for up to 5 years. The judge will reflect the court's withheld finding of guilt, place you on deferred adjudicated probation for a 5-year term. If you serve out the term that you're on for, which can be up to 5 years, do not violate any of the terms and conditions of your deferred adjudicated probation. At the end of the term, the state would dismiss the case against you, the indictment, if you have not violated any term or condition of your deferred adjudicated probation, and there's about 70 of them. Do you understand that?
Yes, sir.
The other side of the road on deferred adjudicated probation is if any time while you're on deferred adjudicated probation, if it's proven to the court that you have violated any term and condition of your deferred, failing to report, fail a drug test, or any other terms and conditions, the state will send the court a violation report. The court will issue a no bond warrant for your arrest. Then there'll be a hearing held. Once you're apprehended to turn yourself in, if the evidence convinces the court you have violated any term and condition of your deferred adjudicated probation, the court would grant the state's motion to adjudicate, go back and find you guilty of the offense of burglary habitation. Then because you were on deferred and violated your deferred, the court could go back, find you guilty of burglary habitation, then assess your sentence at the maximum 20 years in the Texas Department of Corrections Institutional Division, found it up to $10,000. You understand all that?
Yes, sir.
Now, you'll have about 70 or so terms and conditions of your deferred adjudicated probation. I'll sign the judgment this afternoon. That judgment will place you on the deferred adjudicated probation term of 5 years. Your number one term is going to be when you book out of jail, you're going to have a piece of paper, a page that tells you when you are supposed to report to your probation officer. Be sure and look at it and look at the date, because it's different now. You don't go down right out of being booked out of jail, because you have to get now with the situation with the virus, you have to get a date and time, your date and time, and your appointment date and time, and you'll get a sheet that shows that you this. It is Tuesday, July the 28th at 1:30. That same sheet tells you that you are scheduled to meet with your supervising probation officer, Catherine Robertson, Robertson, and it has the date on it. You have to report in person. It's not a call-in deal. You have to report in person to your probation officer, Catherine Robertson, on Tuesday, July the 28th at 1:30. Do you understand that?
Yes, sir.
You'll get all that on a sheet of paper when you do book out. Now, when you report down, if you don't report on July the 28th, 2020 at 1:30, that's a Tuesday, they'll immediately send me a violation report. It'll tell me you did not report as ordered by the court. I'll sign a no bond arrest for you, and it'll be turned over to the warrant officers. Do you understand that?
Yes, sir.
When you report to your probation officer on Tuesday, July the 28th at 1:30, she will go over with you all of the terms and conditions of your deferred adjudicated probation. There's about 70 of them. If you serve out the term you're on deferred adjudicated probation for and do not violate any of your terms and conditions at the end of the term, the state would dismiss the information against you, and you would not have a final conviction on your record if you complete and follow all your terms and conditions of your deferred adjudicated probation. Do you understand that?
Yes, sir.
Now, the other side of the road on deferred adjudicated probation, Mr. Herman, is that if any time while you're on that deferred adjudicated probation, which could be up to 5 years, if you violate any of the terms and conditions of your deferred adjudicated probation, the probation department will send a written report to the court. The judge of the court will issue a no bond warrant for your arrest. Once you're apprehended to turn yourself in, there'll be a revocation hearing held in the court. Now, I just want to be sure you understand this. If it's proven to the judge, it's not a jury trial. It's proven to the judge you violated any term and condition of your deferred, like failing to report, failing to drug test, failing to maintain suitable employment, failing to carry out your community supervision, or any of the other terms. The court would grant the motion by the state, go back, find you guilty of the offense, and then because you're on deferred, the court can sentence you up to 20 years in the Texas Department of Corrections and a fine of up to $10,000. You understand all that?
Yes, sir.
Marcel, is there anything else? Anything? Can you hear me, Marcel?
Yes, Your Honor. He lives
ahead.
in Jacksonville, Cherokee County. He's to report to Smith County, Your Honor.
Yes, as we've seen before, he's apparently going to start, he resigned down in Cherokee County, living in Jacksonville. He'll be ordered to report in person here to the Smith County Probation Office because it is a short drive. Anything else?
Nothing further, Your Honor.
Anything else, Ms. Anderson? Or anything else, Mr. Rollins?
Judge, I have one more thing I'd like to point out to the court before we close this out. The complaining witness's name is Caitlin Baker. Miss Baker, Mr. Chamness and I have spoken to Mrs. Baker a couple of times, and Mr. Herndon and Miss Baker have a child together, and Miss Baker wishes to have contact with Mr. Herndon just for the purposes of, so that way he can see his child.
And that's correct, Your Honor. Mr. Chamness has had direct contact with the victim, and she does not want a no contact order in this case.
Well, that's fine. The court has no problem with that and will follow that agreement. However, that actually has to be written down by the probation department. I use the word written down. That has to be in your terms and conditions. There will not be a no contact provision. It will not say you cannot have any contact or direct or indirect with the victim whose name was just put in the record. But you have to have an arrangement approved by the probation department where you have certain times and days or whatever, where you can have contact with the victim. So what I'm telling you there is when you meet with your probation officer, you'll go over with her and she will set, after talking to you and to the victim, she'll set dates and times when you can have contact with the victim. That's left to the probation officer. She'll determine what the situation is. And then she'll put in your term or condition when you can have contact with the victim. Obviously, the court's ordering your contact with the victim can only be for the purpose of you having visitation with your child. Do you understand that?
Yes, sir.
Mr. Rollins, is there any type of order in the domestic relations court on visitation or anything?
Not that I'm aware of, Judge.
Okay, then work that out with your probation officer. In other words, before you have contact with her, you have to meet with your probation officer so that the term and condition of your probation conforms to what you tell your probation officer in terms, and your probation officer will talk to her. And then your probation officer will, after talking to you and talking to the victim, she'll write that, she will put in on paper the terms of your visitation, that it will only be for the purpose of you seeing your child. And there may be other restrictions on it, but you cannot have any contact with her in person, no contact with her until you meet with your probation officer and get that contact approved by your probation officer. Do you understand that?
Yes, sir.
Anything else, Ms. Anderson?
Oh, Your Honor.
Anything else, Mr. Rollins?
No, sir, Judge.
All right, we're in recess.
You go, but
Blair.
Yes.
Hey, we're gonna do a out-of-county plea real quick. Pongetti's attorney isn't available right now, so give us about 15 or 20 minutes and we'll be back. I'm just gonna put y'all back in a waiting room.
Okay.
All right,
Okay.
thanks.
Hey, Stacy, would you turn the air on?
Mr. West? Mr. West?
Yes, ma'am.
Okay, just making sure we've got the right person and we're about to do your plea. Your attorney's on there. Just don't say anything because we're live on YouTube and everyone else can hear, okay?
Yes, ma'am.
All right. So whenever we'll do him, and then you'll go back.
All right, we're on the record in cause number 241-0449-20, State versus Nathan West, charged with possession of a controlled substance less than a gram by the indictment. Mr. Rollins, you want to waive the reading presentation of the indictment and all the other formalities?
Yes, sir, we will, Judge.
State's counsel, Ms. Anderson, is also present. Mr. West, raise your right hand so I can swear you in. You solemnly swear the testimony you'll give the cause now on trial before the court be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, Mr. West, let me go with this indictment with you. It's up there on the screen. Obviously, you see in the first paragraph, the indictment charges you with a state jail felony offense of possession of methamphetamine in the amount of less than a gram. That's the charge in the first paragraph. That is the charge in the indictment. However, the second and third paragraphs of the indictment have allegations you have prior felony convictions. I'm going to read each one of them to you, ask you whether or not your plea is true or not true. If you enter pleas of true to each one of these allegations in the second and third paragraph, the enhancement paragraphs, it's going to increase your sentencing from a state jail to a third degree on the first enhancement, and then it'll go from a third degree to a second degree. So your full sentencing range on your plea of guilty on this possession of controlled substance will be not less than 2 years and more than 20 years in the Texas Department of Corrections Constitutional Division, a fine of up to $10,000. You understand all that?
Yes, sir.
All right, second paragraph, first enhancement paragraph reads as follows, that it is further presented that prior to the commission of the charged offense, hereinafter styled the primary offense, it's alleged that on the 18th day of August 2007, in cause number 19996-2007, in the 402nd Judicial District Court, Wood County, Texas, it's alleged you were finally convicted of felony offense of aggravated sexual assault of a child. Are the allegations in that paragraph true or not true?
True.
Then the last paragraph, the second enhancement paragraph, reads as follows, and it is further presented that prior to the commission of the primary offense and after the conviction in cause number 19996-2007 was final, it's alleged you committed the felony offense of possession of a controlled substance, and you were finally convicted on the 30th day of January 2017 in cause number 241-1209-16 in the 241st Judicial District Court of Smith County, Texas. Are those allegations true or not true?
True.
Are you entering your pleas of true to both the enhancement paragraphs in this indictment freely, intelligently, knowingly, and voluntarily?
Yes, sir.
No one threatened you in any way or promised you anything to enter your pleas of true?
No, sir.
The court receives and accepts your pleas of true. The court does find the allegations in the second paragraph of the indictment alleging a prior felony conviction for the offense of aggravated sexual assault of a child. The court finds the allegations true in the third paragraph of the indictment alleging a prior felony conviction for the offense of possession of a controlled substance. giving us a full sentencing range now, which is set out in the acknowledgement of admonishments.
Judge, we're gonna have to correct that paperwork on the record that we put in there 2 to 10 years, but it is in fact a felony 2, so it's 2 to 20, and he understands that.
All right, like when I look down, I'm glad Mr. Rollins went ahead and brought that up. If you look at that acknowledgement of admonishments on the screen, Mr. West, it says the offense for which you're charged, possession of a controlled substance, a range of punishment, then it says 2 to 10. That's actually what Mr. Rollins is saying is, of course, correct. It's not 2 to 10. The full range of sentencing is not less than 2 years, nor more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes, sir.
All right, with Mr. Rollins' permission, since Ms. Anderson is in and out of the court's office, I'm gonna let Ms. Anderson make the corrections there under 1 and initial it, which will show the accurate full range of sentencing, not less than 2 years to more than 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Now, Mr. West, your signature is on all these plea documents. Did you go over each plea document with your attorney before you signed and swore to it so that you understood what you were signing and swearing to?
Yes, sir.
All right, raise your right hand. I have to swear you in because 3 of these documents are sworn to. Do you solemnly swear or affirm that the testimony you'll give and the documents you have executed under oath were signed and sworn to by you with a full understanding of the document itself, and that you signed and swore to the document freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, court proceeds and sets, approves the sworn documents. You have a plea agreement. If you enter a plea of guilty, Ms. Anderson is recommending your sentence at 4 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. It would appear there would be a $180 lab fee assessed that you have to pay to DPS for the analysis of the controlled substance. Is that your recommendation, Ms. Anderson, for to do with restitution to DPS?
Yes, Your Honor.
Is that the plea agreement, Mr. Rollins?
Yes, it is, Judge.
Is that your plea agreement, Mr. West?
Yes, sir.
All right, in addition to the plea agreement, we've got an acknowledgement of admonishments. That's the one, Ms. Anderson, with Mr. Rollins' approval. She's gonna correct that number 1 where it shows the full range of sentences 2 to 20.
Yes, Your Honor, I will do that as long as there's no objection there from Mr. Rawlings.
No objection.
There is no objection from Mr. Rollins. That's the 5 admonishments. You understand the 5 admonishments, Mr. West?
Yes, sir.
Next document, you understand you're waiving and giving up your right to a trial by jury, just asking the court to hear the case on your plea of guilty without a jury.
Yes, sir.
You understand the next document, you waive confrontation with witnesses and agree to stipulate testimony on the plea, correct?
Yes, sir.
Then there is a signed and sworn to stipulation of evidence, Mr. West. It's signed and sworn to by you. It's signed and I've now sworn you to it. It'll show you it's sworn to. I'll fill that in. It's the stipulation of evidence. Do you understand the stipulation of evidence is a signed and sworn to written judicial confession by you to all the allegations and the charge in the indictment?
Yes, sir.
You sign and swear to the stipulation of evidence of your own free will, sign and swear to it voluntarily.
Yes, sir.
Court approves stage 2. There's an agreement to stipulate testimony form for a waiver of appeal. All these are signed by both you and your attorney. Request to allow waiver of the free sentence, which is approved, trial court certification of your rights to appeal, and then of course there's certification from you back to the court on advice you've received on your rights to appeal. All these plea documents signed and sworn to by you, signed by your attorney and by the state's attorney.
Right.
Would you still wish to go forward on your plea of guilty to this indictment without a jury, Mr. West?
Yes, sir.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
You've been over everything you're doing in court today, as well as the facts of your case with your attorney, Mr. Rollins.
Yes, sir.
It's competent, Mr. Rollins.
Yes, sir, Judge. He's competent.
Any evidence of incompetence, Mrs. Anderson?
No, Your Honor.
Court of State's counsel signed his consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers of the case signed by the defendant and by his attorney. So, Mr. West, you do understand the allegations, the charge in the indictment, the full range of sentencing, all these plea documents and your plea agreement, is that correct?
Yes, sir.
All right, in cause number 241-0449-20, what is your plea today to the indictment charging you with the offense of possession of controlled substance less than a gram?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you pleading guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today because you have any delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
The court does receive and accept your plea of guilty to the indictment. What do you have as answer?
Your Honor, we offer states 1, the plea packet with signed waivers and admonishments. States 2, the stipulation of evidence, and we note that he is pleading to an information instead of an indictment. Wait, maybe that's not the right case. No, he's pleading to an indictment. So no, states 2, the stipulation of evidence, and states 3, the discovery compliance documents.
No objection, Judge.
I do have a copy of the indictment. Ms. Anderson is correct about that. With no objection, states exhibits 1, 2, and 3 are admitted into evidence. Court having admitted into evidence states exhibits 1, 2, and 3. The court does receive and accept the defendant's plea of guilty to the indictment charging him with state jail felony possession of controlled substance enhanced to a second-degree felony. Court having admitted into evidence states exhibits 1, 2, and 3, and the court finding the defendant's waiver of his rights, execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court finds the defendant's plea of guilty to the indictment was done freely, intelligently, knowingly, and voluntarily. Receives and accepts the plea of guilty. The court does find the defendant guilty of the offense of possession of controlled substance as alleged in the indictment and hence to a second-degree felony. Moving to sentencing, Ms. Anderson.
Yes, Your Honor, we offer states 4, an electronic copy of the written discovery in this case. I'll deliver that to the court office as soon as this hearing is concluded.
All right, thank you, Ms. Anderson. Any objection, Mr. Rollins?
No objection, Judge.
For the case then, based upon the defendant's plea of guilty to the offense of possession of controlled substance, state jail felony enhanced to a second-degree felony. Based upon the defendant's plea of guilty, the evidence admitted into the record, the court does find the defendant guilty of the offense of possession of controlled substance, state jail felony enhanced to a second-degree felony. And the court does follow the plea agreement, the recommendation of the state assessing the sentence at 4 years in the Texas Department of Corrections Institutional Division. No fines assessed. Court costs are ordered paid. Restitution is ordered to the Department of Public Safety. We have $180 for the lab fee analysis. Credit for time served, credit on sentencing, legal reason for formal sentencing, Mr. Rollins.
No, sir, Judge.
Only another court formally pronounces the sentence. Court does find the defendant guilty of the offense of possession of controlled substance alleged against him by the state and its indictment enhanced to a second-degree felony. And the court, following the plea agreement, assesses the sentence at 4 years in the Texas Department of Corrections Institutional Division. No fines assessed. Court costs are ordered paid. Restitution is ordered. Department of Public Safety for the lab fee analysis. Sentence is formally pronounced. Mr. West, you have presented to the court a document signed by you and Mr. Rollins. It's a waiver of appeal. Do you wish to present that document to the court today through Mr. Rollins, which waives and gives up your right to appeal and waives and gives up your right to file a motion for new trial?
Yes, sir.
The waiver of appeals received, accepted by the court following the papers of the cause. Right now, the court having received and accepted your waiver of appeal, formally pronounced sentence, you'll be continued in custody of the sheriff until such time as you can be transported to the Texas Department of Corrections Institutional Division to serve the 4-year sentence assessed by the court. Following the recommendation of the state, the 4-year sentence is assessed with credit for time served. Restitution order to DPS as part of the sentence in the amount of $180. Anything else, Ms. Anderson?
Your Honor.
Anything else, Mr. Rollins?
No, sir.
Defendants continued in custody till such time as he can be transported to the Texas Department of Corrections Institutional Division to serve the 4-year sentence assessed by the court with credit for time served. We're in recess.
Thank you, Judge.
All right, thank you, Mr. Rollins. We're done with that one, buddy.
Yeah, we just have one more now.
Okay, remove that jail, yep. Remove them and then go to your waiting room and see who's there. Okay, so that's them and it's just a middle. And you'll have Castle and Ponjay. Share because oh, yeah, you can, that's fine. Yeah.
All right, the court will call calls number 241-0221-19, State versus Philip Pongetti, Pongetti. That is going to be on an indictment charging the offense of driving while intoxicated, third or more, third-degree felony. Mr. Pongetti is present before the court, I believe. Wait a minute, where's Mr. Pongetti? I see
He's not there.
Mr. Castle, Ms. Anderson, my probation officer, but I don't see Mr. Pongetti.
Okay, he's there now.
All right, present before the court now is Mr. Pongetti. Is Mr. Pongetti over Smith County Jail?
Mhm.
Heard
Low
somebody,
risk.
well, I heard somebody out of county.
That was the last guy.
Okay. All right, so the defendant, Philip Pongetti, who's in custody at a low risk on this third-degree felony indictment, driving while intoxicated. Third-degree felony is charged in the indictment. Second paragraph alleges 2 prior convictions for operating a motor vehicle while intoxicated 2 times. So the full range of sentencing on the enhancements, if proven, would be not less than 2 years to more than 10 years in the Texas Department of Corrections Institution Division. Fine would be up to $10,000. Mr. Castle is present representing the defendant, which Ms. Anderson is present, all by Zoom representing the state. I understood from Denise a minute or so ago that this was for announcements. Is that correct, Ms. Anderson or Mr. Castle, either one of them?
Yes, Judge.
I'm sorry.
Judge, we had been, I'm sorry, Judge, I'm in the
Go
Great
ahead.
County Courthouse.
No.
We'd been set for, and the DA's office has provided us with the new offer. We've had a little bit of trouble discussing it with Mr. Pongetti due to the logistics involved.
Where is Mr. Pongetti?
Yeah,
Where is he?
He's in Smith County.
Oh, he is, he's here. Okay. That's okay. Go ahead.
yes, Judge. We just had some of the trouble in visiting with him, me and him privately. But I think Ms. Langston has set the case for the 5th, and hopefully we should have something figured out where we are in the next week or so, Your Honor.
That's fine, Mr. Castle. When you said the date, I think the computer jumbled it up a little bit. What's the date, Tabitha?
It's Wednesday, August the 5th at 9 o'clock.
Wednesday, August the 5th at 9 o'clock. Correct, Ms. Anderson?
Yes, that's fine, Your Honor. I was just going to say that, yes, Mr. Chamness and Mr. Castle have been talking about these cases to resolve, and I think we would be in agreement then with just extending the plea deadline and the time.
All right, court's going to extend the plea deadline and set it on the date that we just put in the record.
Wednesday, August the 5th
Wednesday, August the 5th
at
at
9 a.m.
Wednesday, August the 5th at 9 a.m. Get a little feedback anyway. If y'all can all hear, Wednesday, August the 5th at 9 o'clock, set for a plea before the court. So the plea deadline's extended to Wednesday, August the 5th at 9 o'clock. Defendants continued in custody at the jail. Anything else?
Thank you, Your Honor.
Anything else today, Ms. Anderson or Mr. Castle?
No, Your Honor.
Is that it, Mr. Castle?
Yes, sir.
Okay, well, defense continuing custody cases next hearing, either pretrial or a plea, set on that, Wednesday, August the 5th, Wednesday at 9 o'clock. Normally, the way we've been doing these, Mr. Castle, that's set on that day. That would be, I suppose it has been in other cases, that would be the plea deadline. So if he's gonna plead, we would have to have the plea in place by that day to go over the trial docket. And if it will be past the plea deadline. That agreeable with you, Mr. Castle?
Yes, sir.
Correct, Ms. Anderson?
Yes, Your Honor.
If there's nothing else, then we'll be in recess. And the defendant who has been here present by Zoom on all these proceedings will be in recess on the case for today until the date that's set for plea.
Thank you, Your Honor.
All right, thanks, Mr. Castle. That it, Ms. Anderson? You got anything else?
I believe so, but I'm going to defer to Ms. Langston.
We're done.
Well, Ms. Langston appears to have understandably absented herself from the courtroom at this time. It leaves into Tabitha, who's advised the court, we're done. I'm not gonna argue with that, but we're done.
All right.